an appeal in the matter of Upitis and another and Respondent.
Yes, Mr. Hedgeman.
May it please your lordships, your ladyship, I represent the defendant appellant, Transport for London. My learned friend, Mr. Mooney, King's Counsel, represents the two claimants in this case. My lords, my lady, we have an hour and a half in this appeal. We're hoping we're not...
A day.
A day, beg your pardon. A day and a half.
Yes.
Will certainly be longer than an hour and a half, but we're hoping we may not be a day and a half.
Yes.
Broadly speaking, I hope to have concluded my submissions by about 3 o'clock this afternoon, and then give way to my learned friend. It will take us through to tomorrow, potentially.
Yes, well, we'll see. Don't feel you have to occupy every minute of the allotted time. We'll see how we go.
As I've indicated, this case relates to two accidents, both of which occurred in a similar way. This case relates to what is known as a stepped cycle track facility. The one in question being on Farringdon Road, southbound, not of course very far away from here. Mr. Young had his accident on the 5th of August 2019. Mr. Upitis had his accident on the 13th of January 2020. Different times of year, but both accidents occurred in the hours of darkness. This case relates to the stepped cycle track facility, as I say, that forms part of Cycle's Superhighway 6, which in a sense is a series of measures and infrastructure improvements to afford cyclists a facility on a route from north to south London, on a particular route from north to south London. I'll begin, if I may, by taking the court to some pictures of the stepped cycle track so that we can see exactly what we're dealing with. Before then outlining how I intend to structure my submissions and then moving into those submissions. With that said, I'll take the court to volume number 2 of the supplementary bundle, please. To page number 580. It's landscape, but the court should see there, southbound Farringdon Road, at the junction just off Ray Street, and in the distance, just where the red traffic light is the junction with Clerkenwell Road. This is the stretch of road that we're concerned with. What page 580 shows us is the position of the road before the cycle track, the step cycle track, was introduced. And my lords, my lady, the court will see there a bus lane in the position that the step cycle track facility now occupies, albeit the step cycle track facility is further over to the footpath to the left of the road, and not as...
Do we know when it was installed?
It was in 2018, my lord, and we've got, for example, on the following page, page 581, we've got some Google photographs. And these are taken in February and March 2018, and they show mid-construction, essentially, as this facility was being built. What then follows in the bundle are a series of photographs showing this step cycle track facility as it has been since it was constructed. And so, for example, on the next page, page 582, we can see a Google Street View image dated April 2019 showing a northbound view in the opposite direction, the view to the way that the cyclists were travelling on this occasion, which shows the start of the step cycle track facility, and the court will note the triangular white incline marker, perhaps this is commonly seen on the speed bump. The court should also see the edge of the step cycle track facility, the granite curbstones, and then the double red lines to the left of that as we look at it. And just before the step cycle track facility is CS6 on the road, Cycle Superhighway 6. What the court will also see just before the granite curbstones is a black hole or depression, or the base of a bollard. A bollard had previously been constructed in that location simply to identify the start of the facility. It had gone by this point in April 2019. I won't take the court through every photograph or Google Street View that we have, and I should say these were all before the trial judge, but looking through them, we do see, for example, at page 586, the bollard not there, and some damage to the first curbstones at the start of the cycle track facility. This bollard appears and disappears throughout the photographs. So we have, for example, at page 594, we have a bollard that has been struck and bent out of position. A closer image of that is at page 595. And then by 596, we have a new bollard installed, but then it disappears subsequently. It is not material.
Do we have the date of these photographs? Because, for example, 597 says it's June 2020, and there's a bollard there, but 595 and 596, do we have dates for them?
I don't believe we do, my lord, no. I should say that the bollard issue isn't material.
Because it wasn't causative.
Because it wasn't causative. I point this out to the court, really, to underline the fact that the central issue at trial in this matter, which occupied most of the evidence and which the judge dealt with at some length in his judgment, was this issue of the bollard, and whether it was a breach of duty for the bollard not to have been replaced by the time of the accidents, and whether the bollard would have made a difference. But as I say, it's not relevant for these purposes, because on the days of both accidents, the bollard wasn't there. And as we shall see, the finding of breach that I submit the learned judge made was that the curb upstand that we've seen in the photographs wasn't protected, as it were, by a barrier of wands along the top of it.
Well, protected or marked out. And the central allegation is failure to warn, isn't it?
Yes, my lord. The difficulty was that the wands that the learned judge found should have been there were not to serve as a warning. They were to serve as a barrier, an impassable barrier, in my submission. We will, of course, look at this as we go through the judgment.
Can you show me where exactly Mr. Young fell and where Mr. Upitis fell?
I can't pinpoint it precisely. What I can...
So far as was known.
Yes. Mr. Young was closer. I think the best place to look is in the bundle we're in, Supplementary Bundle Volume 1, at page 130. Sorry, forgive me, we're in Bundle 2.
We are.
It's Bundle 1. The court should see there a photograph that was taken at some point on the night after Mr. Young's accident. And we can see a close-up there of the start of the cycle track facility. On the previous page, on page 129, we see a photograph taken slightly further back, and the court should just be able to distill a line drawn across from the carriageway over the granite stones onto the cycle track. It's a faint black line.
That's the line drawn on, is it?
Indeed, my lady, yes. That's the line that Mr. Young said that his accident happened.
Yes.
So within 2 or 3 metres really of the start of the facility. Mr. Upitis was further down, not a great deal, I think, and I'll double check, but I think he was about
further away from the junction.
Indeed, about 5 to 10 metres from the start of the facility. So, but both towards the start.
Just before you move on, you were looking at photos in bundle 2. You
Yes.
skipped over a few. You might be coming back to a sort of wider view, but I'm quite keen just to have an impression of what would be seen as the cyclists were coming down this track. Are there some photographs that give us?
There are, my lady. Yes, there are.
583.
I think is the opposite direction, is it? From the direction. Oh no, sorry.
583 is the direction that the cyclists were travelling in, southbound.
And likewise 589.
Indeed, we do have some further back. So, for example, at 588, we can see the approach even further back up the road before the junction with Ray Street.
And we see on 583, 589 a dotted line.
Yes. That is, my lady, an advisory cycle lane.
Yeah, and it covers the area of the junction.
It does.
What about further back from the junction?
We do have... But before I pinpoint the further back from the junctions, well, I should just explain what an advisory cycle lane is. The court may have seen in this case there's references to advisory cycle lanes and mandatory cycle lanes. It can be thought wrongly that a mandatory cycle lane is a cycle lane that cyclists have to use. That is wrong. Cyclists can travel wherever they want. A mandatory cycle lane, which is bordered by a blocked white line, means that cars cannot go into it. So it is mandatory that it is free for cyclists. An advisory cycle lane, as we see at 588 and the others on the approach to the junction, those are cycle lanes. Again, there's no upstand, it's just a dashed line. But the distinction is that cars can use it. Yeah. And that, of course, makes sense because when looking at a junction, cars will need to turn left or move around another vehicle at the junction or whatever it may be.
I recall reading some evidence about that it had to allow the cars into the junction and out of the junction.
Indeed.
And what about further back before the junction?
There are some, I believe they may be attached to Mr. Young's evidence, but I'll just double check that. I'm grateful to my learned friend. Yes, that's 591 shows us a similar view to the one we've just seen. But there are some even further back that are the ones that I'm trying to locate. Yes, in volume number 1 of the supplementary bundles, at page 125, what we see here is photographs, again taken from Google, marked 1 onwards, and they show a staggered approach to this cycle track facility. So, for example, photograph number 1 is the furthest back, some distance before the junction with Grey Street. Photograph 2 is further down the road towards the junction with Ray Street. And then over leaf at page 126, we get some of the photographs that we've already seen.
Right. So in photograph 1 on 125, we see a solid white line.
We do, at the edge of a bus lane.
What does that mark?
That marks a bus lane. And looking at photograph 2, we see the start of a cycle lane further down the road, which is obviously narrower than the bus lane, and marked by a thinner white line. But importantly, that white line is blocked. It's not dashed. And that's because it's a mandatory cycle lane at that stage.
So this is still before the junction?
Yes, these are all before the junction. At page 126, my lady, we see...
Is this sort of between Rosebery Avenue and Clerkenwell Road? And what at the start of the STC?
I beg your pardon, my lord, at the start of...
If I remember rightly, we haven't had a site view.
No.
But if I remember rightly, if you're going back up the hill, so going the other way,
Yes.
you pass some celebrated pubs and eateries on the left and right.
Yes.
And then you get to the junction with Rosebery Avenue.
You do.
So what I was asking was, is number 1 on 125 Farringdon Road between the junction with Rosebery Avenue and where the STC starts?
Yes, it's south of Rosebery Avenue, heading southbound towards the junction with Ray Street, which is where we're concerned with. And then after Ray Street, we get to the Clerkenwell Road.
Yeah. And
So a cyclist travelling in the direction that both these cyclists would come along photograph number 1, where there's the bus lane,
Yes.
and cyclists are allowed to be in the bus lane.
Yes.
And then come to 2, where there's that would be a mandatory cycle lane with an unbroken white line.
Yes.
And then come to the junction with the dotted white line, and then come to the SC2.
Indeed. And I should also point out this, that the reference to Cycle Superhighway 6 is essentially a route name. The photographs that we're looking at page 125 are not part of Cycle Superhighway 6. Cycle Superhighway 6 comes out of Ray Street, turns right, southbound on the Farringdon Road.
right or left?
Right, my lord. It's
Coming out of Ray Street.
yes. As we look at page 126, the road on the right is Ray Street.
Okay.
And Cycle Superhighway 6 comes out of that and then turns onto the Clerkenwell Road. I think it can be confusing because there's also a junction on the left. I think that's Ray Street Bridge.
Yeah.
I'll double check that, but I think it's Ray Street Bridge, technically, is the road name.
So in photograph 4, the articulated lorry coming towards the camera
Yes,
is more or less at the junction with Ray Street.
it is.
Which page?
126.
Yours.
No, overleaf at 127. At picture 5, we've got the Ray Street junction on the right.
Half of it.
Yes.
Yep. Thank you.
So that is essentially the orientation of this facility. This appeal fundamentally relates to the safety of the stepped cycle track facility. And it is the case that in this case, neither of the claimants noticed the curb upstand at the edge of the cycle track facility. Indeed, they thought it was a white line. I will take the court through the key parts of the judgment in a moment, but essentially, my submission is that the defendant was found in breach of this case on a single basis, which is that it had failed to take reasonable steps to remove the hazard of the curb, such as the judge found it to be, that the defendant had built on the highway. And the particular step that the learned judge found should have been taken was, as I say, the installation of wands along the top of the curb upstand. And I will take the court to this, but I do say it is a case in which the learned judge found that the wands were not there to warn of the upstand, or the wands would not be there to warn of the upstand. They would be there to present a barrier because the whole point of this requirement was that cyclists it was designed to protect were not those who had seen the upstand, they were those who did not see the upstand. And so the wands needed to act in concert as a barrier, to be obviously impassable, to discourage them from trying to cross over onto the track.
So you said defendants were found liable for failure to erect an impassable barrier.
Indeed, my lord, yes. That's.
What did the judge say about failure to warn?
The learned judge in my submission didn't deal with any allegation that the defendant had failed to warn.
Surely that was the central allegation in the case.
But it was, and indeed that was a significant part of the issue of this bollard, and whether it should have been there or not, and whether it would have made a difference. As I say, I will go through the judgment in some detail, but in terms of outlining where I'm going, that is the submission I'm making, that the defendant was found liable after two steps, essentially. Step one was that the hazard was a reasonably foreseeable source of harm to careless cyclists, and my fundamental ground of appeal seeks to impugn that. Step two, of course, is that it's not simply enough to have created a source of harm on a highway. That cannot be a breach of negligence, or it can't be a breach of duty in itself. The court has to go further and undertake an analysis of the extent of the harm, the degree of risk against the practicability and proportionality of preventative measures. And that is why the learned judge found that the breach of duty in this case, and then negligence in this case, was the creation of the upstand and not having installed the wands to protect against it. But before turning to the judgment, I should also just make the point that this case involved strong contributory negligence findings. In Mr. Young's case, it was a 70% finding, and in Mr. Upitis' case, it was a 65% finding. And as we shall see, those reflected the fact that they had ignored several warnings about the existence of the cycle track facility, and fundamentally that they cycled across a curb that was there to be seen had they been paying attention. That's the nub of it. The reason why we are before your lordships and your ladyship rather than a judge of the High Court is because of a tension that the learned judge identified when he suggested that this case be transferred up to this court, between a principle that one doesn't have to guard against or warn against hazards that are obvious in their setting on a highway, and case law that suggests, indeed makes clear, that the duty of care when a danger is created on the highway applies to both careless and careful road users. I will just take the court to the learned judge's reasons for giving permission to appeal in the core bundle, if I may, at page 94. The court should see at point number 2, well, first of all, the judge gave permission on the basis that the appeal had a real prospect of success. Secondly, the judge said there is some other compelling reason for granting permission to appeal, namely a tension, actual or apparent, between Yetkin, which we'll of course come to, and other authorities in this field which would benefit from consideration by the higher courts. And essentially, what the appellant is asking this court to do is to revisit Yetkin and clarify what it is dealing with and what it's not dealing with. So that's the reason why we're in front of this court. And indeed, just over leaf on page 95 is the order made by Lady Justice Andrews in accepting the transfer up. and at paragraph 2, her ladyship indicated that she was satisfied that the appeal raises an important issue of principle, and just overleaf at page 96, on the interplay between the principles that there is no duty to warn against obvious hazards on the road, and 2, a duty of care to road users, if it exists, extending to negligent road users. That is, of course, the point that most of my submissions are going to deal with.
Is it your submission that no duty of care was owed to these cyclists?
Indeed, my lord, yes, on the basis that, in my submission, by the time that the learned judge found, as I will submit he did, that this curb was there to be seen, that there were indications that the curb was there, namely the up-ramp and the double red lines at the edge of the carriageway, which are, as the Highway Code says, lines that are found along the edge of a carriageway. All of that on the judge's findings was enough to put any cyclist on notice that there was a curb up.
That's a question of breach. It's not a question of duty. If the judge is right to say that the installation of an STC here gives rise to a foreseeable risk of injury, that's going to be a duty that's owed to all road users.
Yes.
Fine. Well, that's cleared that point. Then the question is it reasonable for the defendant not to have done more to ameliorate the risk?
Yes.
Right. And as I understand it, your case is the only case that was being advanced against me was a failure to warn. The only warning that was in play was a bollard, and that's been found to be non-causative.
Yes.
Is it any more complicated than that? But it is more complicated than that because you've got the stage 2 and stage 3 reports, both of which identify it and set out steps that TfL are going to take to, in the face of that risk.
Yes. Which and TfL did take.
They did take. Thank you for confirming that. And then, so surely the real question is balancing the magnitude of the risk and this potential seriousness against it. Are those steps which they took a reasonable response to it?
Yes.
Well, that's not a day and a half.
No, I see that, my lord. I suspect the confusion arises because and this perhaps goes to, I think, the second stage for your lordship's indication, which is, well, balancing the magnitude and seriousness of risk. Essentially, is it a danger or a hazard that there is a duty to guard against or warn against?
Yes, but if the danger is too great, risk is too great, that it cannot be reasonably obviated or ameliorated by steps that can be taken, then you can't put an STC in this place.
Yes.
Right. Okay. Well, we understand each other.
I don't think that's being suggested, is it? I mean, Mr. Mooney's case is not that step cycle tracks are an abomination which should be removed from the face of London. At least I don't think it is.
No, but sorry, I may have I may not have expressed myself very clearly. Once you've identified, what I was suggesting is once you've identified an unacceptable danger, risk of danger, if there's no other way of obviating the risk or making it reasonably acceptable on the balance, then you've got to do something different. Like not have an STC there.
Yes,
it's not what this case is about, but it's the way the analysis goes, isn't it?
Yes, although I do make the submission, and as I say, perhaps the confusion creeps in because the cases that talk about obvious dangers, obvious hazards, normal, ordinary features of the highway, those are sometimes referred to as cases in which there is no duty to guard against. But I suspect it's a distinction without a difference, to come to your lordship's point, which is that essentially what those cases are saying is that the risk, such as it is not one that the law requires the defendant to guard against.
They're usually naturally occurring hazards, aren't they? The cases that you're talking about. There are a lot of cases in the bundle that don't seem entirely relevant to this appeal.
Yes, they are. They are. So, for example, Tomlinson, a well-known case, that was a case of a natural feature on the land.
The council built a lake.
Yes.
No.
In a quarry, in a disused quarry. But that principle has been extrapolated into the highways context. And there are a couple of cases I was going to take the court to where that principle does underpin the decisions in the highways context on the basis that all road users, be they cyclists, be they motorists, are expected to cycle or drive with due care and keep an eye out for hazards such as curbs. That's the point that I'm going to be making. But I entirely accept that whether one frames it as a scope of duty issue, which is, well, does the duty require this hazard to be guarded against, or whether one frames it as a breach issue and the balance doesn't tip down in favour of doing something about it, we perhaps get to the same point. I think, if I may, I want to perhaps unusually take the court to the evidence about the types of segregation, the options for segregating the cycle facility from the carriageway proper, that was before the court, before I then, as I indicated, turn to the judgment itself, because it's clearly important that we go through that judgment in some detail. And this is really with a view to what was an important issue in this case, which is the judge's finding that there needed to be this barrier of wands along the edge of the cycle track facility. Essentially, the submission that I'm going to be making is that when one looks at the options for segregating a cycle track facility from the carriageway proper, there is a hierarchy or a structure of options. The gold standard, if I can use my words, the gold standard is full segregation, such as an island between the cycle track and the carriageway, or, as in this case, a stepped track facility where there's a raised curb upstand. Where that's not possible or convenient, there are alternative options, which are called light segregation options, where there is no difference in level or no upstand, but objects such as wands being placed along the edge of the cycle track facility. The important point is that what the learned judge did in this case was essentially say you needed both. You needed the curb upstand needed to be there, but it should have been built with wands along the top of it. So essentially combining a method of light segregation with a method of full segregation. And just to show the court where that is in the evidence, if I could go, please, to the witness statement of Mr. Artis, who was one of two witnesses that Transport for London called, and whose statement can be found in volume 2 of the supplementary bundles, at page 329. It's the extract that I'm going to go to. I should say Mr. Artis was from the defendant's design department. Mr. Coventry, whose evidence we'll come to later, was from the defendant's road safety auditing department. And the two departments serve very different functions. And in fact, there's an element of challenge between them, which we'll look at. But Mr. Artis is the gentleman who gave evidence about the design and why it was built in the way that it was.
Before you get going, Mr. Coventry's statement, which is not where you are, has says it's got appendices AC1, blah, blah, blah. But as far as I could tell, AC1, AC2 and AC9 are not in our bundles.
Yes, my lord. We were over the 350-page limit for the supplementary bundle, and by quite some margin. We've filleted out exhibits that are either duplicates or exhibits that the court doesn't need to see. Most of those exhibits are the road safety audits. We've put the ones in where the issue was raised and the issue was dealt with by the design department. But I don't think the court needs to see all of the other road safety audits not being relevant to this issue. At paragraph 7 of Mr. Artis's statement, in fact, forgive me, paragraph 11, Mr. Artis, having described the need for separation, he says towards the bottom of paragraph 11 on page 329, an on-carriageway cycle facility can have full separation by way of a step track. Step cycle tracks are vertically separated from the carriageway in order to provide greater protection to cyclists. At paragraph 17, he says, due to traffic volumes at this particular location on Farringdon Road, it was necessary to segregate cyclists for a greater level of safety and comfort than a painted mandatory cycle lane would provide. And then finally, at paragraph 22, he says, he makes the point that we've canvassed already, that cycle Superhighway 6 comes out of Ray Street, and then says, so from that point south, the separation between traffic and cycle lanes has to exist because there is a certain volume of traffic, and we need to separate it with either an island or step track or wands. There needs to be a greater degree of separation than a painted line. So Mr. Artis is making the point there that essentially Transport for London was faced with a choice. We need to separate cyclists from traffic because of the location and volume of motor traffic in this area. That requires us to consider either an island, which, as we'll see, is where there is a raised curb on both sides of the cycle track and the carriageway. There's a concrete island, raised island down the border, or a step track, which, as we know, is what was installed in this case, or wands. And the point that I underscore at the moment, and I'll take the court in a second to the standards, but the point is that they are alternatives. There was never a suggestion that wands should be built on top of a raised curb. As I said earlier, combining light segregation with full physical segregation.
Can we just look at paragraph 25 there as well? And I appreciate this is under this section bollards, and obviously the point is there about the judge's finding on causation. But Mr. Otis there says that TfL's general approach now is that it should be a bollard or wand at the start of step cycling tracks to highlight that something in the carriageway has changed.
Yes.
Is that not highly relevant to this case? Because the risk that was identified was that a cyclist would confuse what had come before for what was ahead of them.
Yes. In my submission, my lady, it's not. The purpose of the bollard was to inform cyclists that they were entering a cycle track. It was not to highlight the difference in level.
Right. Mr. Otis says there to highlight that something in the carriageway layout has changed.
Yes.
They're a wayfinding tool.
Indeed. So that's to make the point that they're entering a cycle track facility. So, for example, as we've seen before that, it's an advisory dashed line cycle facility which motorists can cross into, whereas the bollard, and of course the bollard had on it an image making clear cyclists on the left, motorists on the right. The bollard was simply to identify that.
But I think we can see the cycle logo on the cycle track.
Yes.
As well as the step cycle track. So
yes.
So the presence of the logo doesn't identify that there's a height change.
No, it doesn't, indeed. And that's exactly my point, my lady, that it wouldn't do that.
No.
It's simply to identify the start of a facility that is solely for the use of cyclists and not motorists. Just before turning to the judgment, I would like to take the court to the standards that set out the various methods of segregation. And staying in Supplementary Bundle Volume 2, could I take the court first, please, to the Department for Transport's note on page 534? The court should see there the right-hand column that's entitled Step Cycle Tracks. I'm not going to read it all out verbatim, but I would just highlight to the court in particular subparagraph 6.2.26, which sets out the key advantage of step cycle tracks.
Sorry, just remind me what this document is.
Sorry, my lady, this is the Department for Transport's note on cycle infrastructure design.
Six 227 is interesting.
Yes.
What does fully battered mean?
I suspect, my lord, it means at points where cyclists are to join or leave the step track, it's battering down the upstand so that there's no difference in level, or a lesser difference in level, perhaps. So that essentially that's to deal with an entry or exit point on the step facility along its length somewhere.
We don't have section 10.
I don't think we do, my lord. No, I think we again, to keep the bundle short, we omitted that. In terms of light segregation, we find what the Department for Transport has to say about that at page 538. And at paragraph 6.3.1, the Department for Transport say light segregation describes the use of intermittent physical features placed along the inside edge of a mandatory cycle lane. And as we've seen, that's a blocked white line, flat painted edge to give a greater perception of safety, which is important to encouraging people to cycle. And then the Department of Transport's note goes on to talk about the advantages in certain settings of light segregation, of which wands are an example. We can see at paragraph 6.3.3, a variety of features can be used, such as traffic wands.
In the proprietary raised features are the things that you can see on the camera side of the planter in figure 616.
Yes.
Yeah.
But the point, of course, with all of these things, be they planters, be they wands, be they those raised features, is that they are intermittent and cyclists are entitled to cycle between them. And that is why, in my submission, we have light segregation through wands as an option for the edge of a mandatory cycle lane, because that is flat. The edge of a mandatory cycle lane is flat. And so this is a submission that I'll make later, but there is a real risk in this case that if the law's requirement is that the stepped track has to have wands placed along its length, that, in my submission, is a recipe for confusion, because cyclists are used to seeing wands in areas where they can go between, where they can cycle between. it's almost, I don't put it this high, but it's almost an invitation to weave between the facilities, the carriageway proper and the cycle track.
But why is there no physical difference other than the triangle and the double red lines going around the corner? There's no physical difference to distinguish the step cycle track from another cycle track.
I beg your pardon, Madam, to distinguish the step cycle track from?
From, let me call it a flat cycle track, i.e. one that's at the same elevation as the main carriageway.
Well, in my submission, my lord, there is, because we have the curb, and the height of the learned judge's findings was that at a point before getting to the step cycle track, it's not entirely clear how far back up north the road the learned judge was thinking, but at a point further up the road, the step cycle track could be mistaken for a white line. But the learned judge's findings are very clear that at the very latest, at the point of the start of the step cycle track, the curb was there to be seen. And that explains why we have the 70 and 65% contributory negligence findings. At that point, the curb could be seen, and it's a...
Sorry, I'm just confused by your submission. You said further back there could be confusion, did you?
Yes, my lord. So the learned judge's findings, perhaps I should be going to the judgment to take the court through it. It's in the core bundle. I wonder if we could pick up the judgment, please, at page 82 of the core bundle. And what I intend to do is to run through the key paragraphs in the learned judge's discussion and conclusions in order to set out the errors, to signpost the errors that the learned judge in my submission made. But importantly also the findings that he did make. At paragraph 125, the learned judge sets out the relevant question is whether the risk was reasonably foreseeable, and if it was, whether TfL could reasonably have taken steps to mitigate the risk so that it was no longer reasonably foreseeable. And then the learned judge says, I remind myself that their duty was not to give warnings of obvious hazards, it was not to create such hazards in the first place. And this is where, in my submission, the learned judge starts to misdirect himself, because whichever way one reads that paragraph, he's saying very clearly the duty that the defendant owed extended to an obligation not to create obvious hazards. And in my submission, that clearly can't be right. The duty exists, or the scope of the duty exists, where a real source of danger has been created as distinct from an obvious hazard.
Well, you wouldn't take issue with paragraph 124, would you?
No, my lord, I wouldn't. Essentially there, the judge is simply making the point that the common law duty arises once a reasonably foreseeable risk of harm is created.
Yes.
And then the final sentence, however, TfL was required to do no more than was reasonable to avoid such a risk.
Yes.
Assuming, and this is a point that my learned friend takes, assuming that final sentence includes that it may be reasonable to do nothing at all. In other words, the extent of the danger such as it is might not be something that needs to be guarded against in law. Assuming that can fall within that last sentence, then no, I have no issue with that.
No, the first part defines the duty as a duty not to construct it in such a way that it gave rise to a reasonably foreseeable risk of harm, qualified by TfL required to do no more than was reasonable.
Yes.
So there's nothing wrong with that, is there?
No,
that
there's
sets
not.
out the duty very clearly.
Indeed. And then, as I say, paragraph 125.
Terry, sorry, it's my fault. I didn't quite hear. Which passage were you looking at?
124.
Yeah, okay.
Paragraph 125, we've got the point that I've just made, that I do say, and I think the claimants in their skeleton say, well, this is unfortunate wording, so it's infelicitous, but in my submission it goes further than that.
You say it vitiates the whole judgment.
Yes, my lord, because as we'll see as we come along through the following paragraphs, what the learned judge does is, having found that there was a reasonably foreseeable risk of harm to careless cyclists, the judge doesn't then take a step back and say, well, is this something that needed to be guarded against at all? Did the defendant need to do anything to protect negligent cyclists?
To protect cyclists.
Yes. But what the learned judge goes on to do is simply give three possible things that could have been done, and his views on whether they should or should not have been done. But as I say, we'll come to that.
Well, there was a reasonably foreseeable risk of harm to cyclists. In fact, there was a foreseen risk of harm to cyclists because the risk assessments identified it.
My lady, yes, well, the road safety audits identified it, and then the design team, as we'll see, say, well, we've taken into account that risk by putting in place various measures that were put in place.
Well, isn't the whole question then whether the measures they took were sufficient?
Yes.
Not
Indeed.
necessarily to do away with the risk altogether, but to make it an acceptable risk when the balance is struck.
Yes. This all comes back to the balance that has to be struck. And
forgive me for asking, but I think although he rehearses the fact of the audit RSA's raising and the response of the design team, there is in fact no analysis of the balance.
no, and my lord, this is the point that I think in answer to my Lady Justice Yip's point, that what the judge does is find that it's a reasonably foreseeable source of harm, and then go straight into options that could have been explored to mitigate it. The learned judge doesn't conduct a graduated risk assessment of the extent of the harm, how significant the level of harm is. And one of my fundamental grounds of appeal is the judge's failure in my submission to take into account the very low accident rate as compared to usage.
And that's relying on WSP.
Partly. It's partly relying on WSP, who conducted a survey tallying up the numbers of people using these pieces of infrastructure. But there was also evidence of another survey that the defendant had done. And there is also evidence of the number of accidents reported on this stretch of road. Despite, and that's how I can take the court to this evidence, but despite cyclists using Farringdon Road going up by about 300% since this cycle track was installed, the accident rate, cyclists colliding with pedestrians and vehicles, whatever it may be, has decreased.
So just to get the extent of the issues, really, we've got that the duty is straightforward. I think you agreed the question is whether the measures taken by the defendants were reasonable.
Yes.
And your point really is that the analysis conducted by the judge was just wrong. He just didn't take into account relevant factors. And
yes.
Yeah.
Essentially, the judge does two things. He says there's a reasonably foreseeable risk of harm, and there are three matters that TfL could have thought about to reduce it. There is no graduated assessment of the extent of that harm on the claimant side of the balance, if I can put it like that, and there is no analysis at all of the practicability the proportionality, and the effectiveness of the methods that, that the learned judge identified.
I mentioned WSP a minute ago, and you said there's 3 other or 2 other sources. Are you going to give us the references to them?
I will, yes, my lord. I will. I'll perhaps, if I may, I'll stick with the judgment for now.
Please do.
And then build my submissions by referring to the parts of the evidence.
Can you just tell us who the witnesses were at the trial? The 2 claimants, Mr. Hotterpoff, who...
No, my lord, he didn't attend trial.
Right, so written statement from him.
A written statement from him.
And
I, of course, didn't have an opportunity to cross-examine him. But
and that was it for lay evidence. And then the 2 quasi-experts.
There was one more evidence one more witness for the claimants, a gentleman called Mr. Monk,
Right.
who was a member of, I forget the name of it, a member of a campaign group for cyclists.
Oh dear.
He gave some
Had
evidence.
he suffered an accident?
No.
No.
No,
Right.
he was giving some views.
And there was no provision for the claimants to call experts.
No, there was no expert evidence in the case.
At least one of the claimants had sought permission to call expert evidence, and that had been refused by the district judge.
Yes, I understand that's right. I've seen it in my learned friend's skeleton. Yes.
It'd be quite difficult for the judge to have conducted an analysis of proportionality and effectiveness if the claimant wasn't allowed to call expert evidence.
Possibly, my lord. This does take us into a ground of appeal that I'm going to combine, which is the issue about pleadings and the issue about Mr. Coventry's evidence and the matters that were put to him, and whether essentially the answers Mr. Coventry gave could have sustained the method of wands on top of the curb that the learned judge found should have been put in place. But one would have to assume that in deciding whether permission for an expert was required, the district judge would have been looking at the pleadings and what the allegations were. My submission is, of course, going to be that this point about building wands on the edge of a cycle track was not in pleaded issue. What was in pleaded issue, and which occupied, as I say, the majority of this trial, was the issue about the bollard and whether that was there or not. And one can see that the court wouldn't need an expert on that. But I absolutely accept that if the issue in this case, as it turned out to be, is whether step cycle tracks should have wands installed along them, then that, dare I say, the defendant may have taken a different view on the need for expert evidence at that stage.
Okay, where do we go next?
So I think, my lord, we're at page 82. We've dealt with paragraph 125, and essentially my submission there is that in finding that or setting out that the question was whether TfL could reasonably have taken steps to mitigate the risk, so it was no longer reasonably foreseeable, i.e. there was no source of harm at all, and in saying that the defendant's duty was not to create obvious hazards, there is just a danger from that, and it's a danger that I say came to fruition, that the judge is prepared to set the standard of care too low. That's essentially where that point will go. And at paragraph 126, the learned judge said that he bore in mind Lord Brown's observations in Gorringe, which we'll come to, that road users are not entitled to suppose that their journeys will be free from hazards, or that the need for care will be highlighted. But he balances that, the learned judge balances that with Yetkin, which is where we get in to this issue that the learned judge raised in appeal and Lady Justice Andrews referred to, which is essentially, is it right to treat Yetkin as something that deals with the type of dangers that need to be guarded against? And in a nutshell, my submission on Yetkin is that it is all about who the duty is owed to it is not about what the duty is owed for. That's the submission that I'll be making there. At paragraphs 127 and 128, the learned judge deals with the submissions that I advanced about the accident rate. He dealt with the submissions that I made based on Tomlinson about the need to put the number of accidents in context, to examine and assess the extent of the risk, by simply distinguishing Tomlinson on its facts. And I said the learned judge was wrong to do that, because, of course, whilst Tomlinson could plainly be distinguished on its facts, the principle of law, that it is germane for the court to consider the extent of the risk by reference to how common accidents are, is something that the learned judge should have taken into account, but in my submission didn't. And we have the same point at paragraph 128, where the learned judge, in dealing with a case in which 12,500 cyclists had cycled over a depression or around a depression in a road during a cycle event, and it being found on appeal that the trial judge was wrong to ignore and not take into account the fact that 12,500 cyclists had used the area without incident, to mean that there was no duty to do anything about it. The learned judge passed over that by again referring to Yetkin. And this is essentially the same error, that what the judge is not doing here is grappling with the issue of the sheer number of cyclists who have used this facility without any problem against the handful, and it was no more than a handful of instances where cyclists had come to injury. At page 83, at paragraph 130, the learned judge here makes the finding that a reasonably careful, i.e. non-negligent cyclist, even if they'd not noticed the triangle, would notice the double red line, appreciate that double red lines typically occurred along curbs, and be aware that curbs often had an upstand. If, as they should have done, they did notice the triangle, this would inform them that the SCT was on a higher level than the carriageway. A cyclist who noticed neither the double red line nor the triangle would be a cyclist who was simply not paying attention to their route. So at this point, the learned judge is dealing with those mitigation measures that the defendant had put in place, and the learned judge was accepting that those measures were enough to put a cyclist that was paying attention on notice of the curb. At page 84, paragraph 135, we come back to the judge framing the duty and the question, or the breach question that he needed to determine. At paragraph 135, the learned judge said the question for the court is whether, in light of the widened curb, painted double red lines and painted white triangle, the curb upstand posed a reasonably foreseeable risk of injury at the dates of the accidents, and if so, whether there was any further steps which TfL should reasonably have taken to reduce that risk so that it was no longer reasonably foreseeable. So again, we have this creeping into this judgment, the notion that the elimination of the risk point, which I say that was too far.
So by that you mean he's expressing the duty as a duty to remove all risk?
Essentially, yes, my lord. Yeah.
That's your submission
yes.
about what he's doing?
The learned judge goes on to say, and this again is a repeat essentially of the points he made earlier, he was satisfied that the painted double red lines and painted white triangle would have been sufficient to warn a reasonably careful cyclist not to attempt to cross from the carriageway to the SCT over the curb. He also says, importantly, bearing in mind that both of these accidents happened at night, or in the hours of darkness at least. I'm also satisfied that these markings would have been visible in the lighting conditions present at the time of both accidents. We are therefore concerned with whether it was reasonably foreseeable that some cyclists would fail to appreciate that risk.
It clearly was.
I beg your pardon, my lord?
It clearly was, but your submission is that's not the test.
Yes. The following paragraphs deal with the issue of the bollard.
Just before you move on, can you just help me about the widening of the curve? That was after the first reported accident, was it?
Yes, so it's the other end of this step cycle track facility. It's the junction of Clerkenwell Road.
So nothing to do, the widening wasn't in this area?
I don't. What I certainly know is that it was widened at the junction with Clerkenwell Road. What I don't know is whether the cycle track had been built at that stage at the Ray Street junction. But the difference was there were 2 points of difference. The first is that the curbstones were positioned upright, so they were thinner. What happened is that they're essentially, in the construction we see now, they're turned on their side. But they were positioned upright. So that made the
Right.
curbstones thinner. The second important difference was that there was an upstand on each side. So the cycle track facility
Right.
and the carriageway both had an upstand. So it was essentially a thin island.
Sorry, so you say this is the other side of the road?
This is the same side of the road, southbound, but it's the Clerkenwell Road junction. And Mr. Hotop's accident at that location was in 2018, around the time that all of this was being built.
Right.
Sorry, I'm getting confused. We can see from the photographs that at the location that we're concerned with, curbstones are laid in the normal way.
Indeed.
So this thing about standing them on end or whatever isn't relevant where we are.
No.
Okay.
No.
No, so
But what the learned judge is referring to is that TfL did take a step, at least at the other end of the cycle track, to turn the curbstones from the vertical position onto the side.
And that may have coincided with being around the time this part of the track was being constructed.
Yes.
So we can see they're laid the conventional way,
Yes.
which means that they are wider. The line that it creates, using that in a neutral way, is wider than the white line further back.
It is. So we saw that there's the, well,
Judge makes
immediately
finding
before the
that.
step cycle track is the dashed white line,
Yeah.
because it's advisory, cars
Yeah.
can turn and move across it. Prior to that, it's a thin blocked white line.
Yeah.
So a mandatory cycle lane.
When you say blocked, continuous.
Continuous, yes. Continuous rather than dashed.
Sorry to go on niggling about what happened down by Clerkenwell Road, but is the effect of that there was an upstand both on the outside of the cycle lane and also from the curb down onto the carriageway?
Indeed, my lord.
So there were two trips, as it were.
Yes. So in theory, a cyclist on the track could move into the carriageway and come a cripper.
Exactly.
And the judge made a finding, didn't he, that the solid white line before the junction, effectively he made a finding was thinner than the curb here.
Yes.
He put it the other way around.
Yes. The following paragraphs deal with the bollard point, which I'm not going to spend any time on. Can we look next, please, at paragraph 143 on page 85?
Have I got this right, Mr. Hedgeman? The effect of the upstand is that if you're a cyclist and you pass this junction and you don't enter the step cycle track at the entrance with the white triangle, it's dangerous to use it at all until the next junction.
In what respect, my lord, is...
Well, you
Dangerous
can't,
to try to cross onto the cycle.
you can't cross onto it because you say you should have known, but there is an upstand.
Yes, there's a 5 to 6 centimetre upstand curve. Yes.
There was some evidence that cyclists do
I was just
bump up and down the curve.
this is the WSP report. There were evidence that cyclists deliberately wanted to enter it at a point other than its beginning, and that people would bump up to it, bump down to it. One can imagine very simply that a cyclist who determined that's what they wanted to do would need to turn into it at a more of an acute angle.
If it's a flat cycle track, then there's no problem. You obviously have to make sure you're not cutting in front of somebody to cause a collision, but there's nothing on the ground to make it dangerous. But with this, unless you really know what you're doing and you're riding into it, bumping up, it's actually unsafe to join at any time after the start.
And
Yes.
is the trade-off that it reduces the risk of motor cars coming into the cycle track?
Well, this is exactly the point, Model. This is the fundamental trade-off that the learned judge, in my respectful vision, did not have in mind, which is that we're dealing here with a protected facility. We're dealing here with a method to protect cyclists from the perils. Often the cyclist will not be at fault in the slightest. The perils of being on the carriageway with buses, cars, taxis, lorries, we've seen an articulated lorry, that is the peril that the cycle track facility exists to protect against. And in my submission, and my Lord Justice Smith, this is a point that I will take the court to in the evidence. The cycle track has served that purpose because it is protecting the hundreds of thousands of people that use it. The trade-off is that for a handful of careless cyclists, negligent cyclists, they may cycle into the curb. But as I've said in my skeleton, that is very much in the control of the cyclist rather than being at the mercy of a negligent motorist. And this goes to the point, and this is why we're before your lordships and your ladyship, because as it stands, this cycle track on Farringdon Road is negligent, not having ones alongside it. And so what are TfL to do? Are they to stop building them? Are they to remove the ones that are there because, for whatever reason, it's not going to be possible or appropriate to put ones along all of them?
I'm not sure that that's right. The risk that was identified in the construction phase was that as a cyclist came along the level track with a white line, through the junction, which is a dotted white line, but we know it's dotted because it's a junction, that they would then see effectively a continuation of a cycle track with a white line. So it's just that very point, isn't it, that we're considering. Not all SCTs or even the length of the SCT, but whether the risk of confusion as you come to that cycle track was properly mitigated.
We are, but I suppose the point that I make, my lady, is that given that these step cycle tracks are not just on Farringdon Road, they're in other locations, and they don't have wands along them, they don't have warnings of the upstand, and given that they're not just in London, there is evidence in the bundle that they're used in other parts of the country as well. If it is right in this case that this cycle track, even at the start, is negligent, then in my submission there's no reason in principle why that wouldn't extend to any other one.
So a cyclist approaching this has to notice that there's a change from the level cycle track that they've been on previously into a raised cycle track. And the features that should identify that for them are the red lines, the double red lines, and the marking at the very front.
And the curb itself, in my submission. I think we're at paragraph 143 on page 85. This is where the learned judge returns having dealt with and dispensed with the bollards issue, if I can put it like that, the learned judge returns to whether the curb posed a reasonably foreseeable risk of injury. This is where the judge makes his finding that when approaching the SCT while cycling south down Farringdon Road, it would be easy to mistake it for a continuous white line. And he says that I've made that observation having seen the photographs of the curb and with the benefit of a site visit.
Sorry, I've read that before, but I can't. What paragraph number is it?
143, Millie.
Thank you.
And the judge finds that that was reasonable. What is not clear is the point at which, on the approach, the judge is saying that it would be easy to mistake it for a continuous white line. We don't know whether the judge is talking about at the junction. We don't know whether he's talking further up Farringdon Road, up north, further back in the approach.
When he says it, he must mean the upstand, mustn't he?
Yes.
Yes.
Well, yes, the curb's forming the upstand. Yes.
It's got to be the line of the curb,
Yes.
because the line of the curb is distinguishable from the cycle carriageway,
Yes.
Yeah.
and it's a different material and so on.
Yes. But it's an important point because it's easy to understand how a cyclist with the naked eye can't be expected to distill a curb further up the road. Who can distill a 5-6 centimetre difference in level further up the road? But of course, the point that the judge goes on to deal with is that once someone is at the SCT, and again, it's not quite clear whether he's saying at its commencement or just before it, but what the learned judge is saying is that at that stage, it is all there to be seen.
The
Where do
real
you say
hazard.
that? Where do you see he says that? I'm so sorry.
That, my lord, is on page 87 at paragraph 150 in dealing with contributory negligence. Had they been cycling with reasonable care and skill, they would have realised that the cycleway was bounded by a curb and not a line, and would not have attempted to cross it. So it's there to be seen. There is...
See, the real hazard is that a cyclist coming through this junction will think that it's a continuation of what was before the junction, and therefore position themselves to overtake, or for whatever reason position themselves at the junction so that they're not square on with the cycle track, and then attempt to get back on the cycle track. That's what the judge is identifying at 143, isn't it?
Well, the closest we get, my lady, is the judge says when approaching the SCT while cycling south. He doesn't say at the junction. And earlier in the judgment, the judge refers to going further north up Farringdon Road, the slope down towards the junction and so on. So he's...
There's reference somewhere to there being a downhill slope approaching this, so that cyclists are likely to pick up a bit of speed.
Yes, although not at a speed beyond 20 miles an hour, which is the limit.
Yeah.
And it must be right that when building these things, the designers should appreciate cyclists travelling up to the speed limit, whether it's by manual propulsion or whether it's coming down a gradient, matters not. Importantly, of course, there is a junction that cyclists have to negotiate after that slope, a traffic light controlled junction. So it's an area where a cyclist should be keeping a proper lookout.
Keeping a proper lookout at a junction involves looking ahead, looking to see if vehicles are coming, not not looking at the ground.
Yes, well, I mean, in my respectful submission, a cyclist has to do both. What one has to have one's wits about them at a junction, but also at the road ahead. But in this case, the strong contributory negligence findings of 70% and 65% really, in my submission, bear out just how negligent it was for the cyclist not to see the curb and to not have seen the warnings. We, just before continuing with this judgment, I want to highlight at this stage there is a dispute between my learned friend and I, it seems to me, about exactly what the finding of breach is. Because as I understand it from a learned friend's skeleton argument, the finding of breach is the fact that this curb was a danger. My learned friend says that is the breach. And I can take the court, perhaps if we just turn it up to the claimant's skeleton argument. At page 47 of the core bundle. Three paragraphs that I wish to take the court to. Paragraph, first of all, number 32. It said, the negligence was creating a hazard on the highway. The installation of wands was just one of the potential measures that could have been used to mitigate the danger and make it reasonably safe. And then at paragraph 34, it said again, the negligence was the creation of a danger on the highway, not the failure to institute wands. Wands were simply a potential solution to the danger which had been created. And then finally, just over leaf at page 48, at paragraph 39, the wands point only goes to the measures the appellant could have taken to rectify their breach of duty. So there does, it seems to me, to be a dispute between us about what the breach was that the learned judge was finding. In my submission, the learned judge was not finding, as the claimants contend, that the existence of the curb upstand was a breach of duty. The learned judge found that the installation of the failure to install the wands was the breach of duty.
Well, you're just coming to paragraphs 145 to 148.
Yes.
Hadn't we better look at what the judgment says rather than what counsel says it says?
Yes, indeed, well, that's exactly where I was going to go. Returning to paragraph 143, what the judge says here is simply that it was reasonably foreseeable that some cyclists would make that mistake. In other words, confusing the white line for the curbstones. Forgive me, confusing the curbstones for a white line. What the judge does not do in paragraph 143 is saying that's negligent. All the judge is doing there is starting to deal with the first part of the balancing exercise, which is the question of reasonable foresight of harm. The judge is not finding that the curb upstand is a negligently introduced hazard. He's just found it's a hazard at this stage. At paragraph 144, the judge then sets out the next question. Were there any further steps which TfL could reasonably have taken to remove the hazard posed by the curb? And then the learned judge goes through three possibilities. I don't think I need to trouble the court with the first two because the judge didn't find that they were steps that TfL needed to have taken. The third possibility is that which we can see at page 86, paragraph 147. And this is the possibility that was argued by Mr. Upitis' counsel only, that wands should have been used to create a barrier between the SCT and the carriageway. And then we've got references to Mr. Coventry's evidence that I'm going to come on to later. And the judge essentially set out some of the benefits of wands and then simply concluded, I am satisfied that there is no good reason why this could not have been done. It would have been a reasonable measure which would have removed the hazard posed by the upstand, so that the upstand no longer posed a reasonably foreseeable risk of injury to cyclists. And the whole purpose served by those wands is to act as a barrier so that a cyclist wouldn't attempt to cross.
And the motorist would not attempt to cross.
And motorists. So I do make the submission that paragraph 147 is where the finding of breach in this case is made. It is not, as the claimants say, this is just simply a point or a possibility that Transport for London should have thought about to rectify its breach of duty for having the curb upstand there.
Am I right? In the materials that you have put in, including the TfL materials and the Department of Transport, is there any place where, as part of design criteria, the installation of wands on a STC is advocated?
No. And this is another criticism that I have of the judgment, that what is in the standards is something that is relevant to be taken into account. It's not determinative, of course, but it's relevant. And in this case, the learned judge simply doesn't refer to the standards in conducting his analysis of the balance in determining breach of duty.
And it wasn't separately alleged that the construction or the as-built STC, with or without the bollard, breached any relevant standard?
No. And we will see part of the trap that the learned judge has fallen into here, and this is the point when I take the court to the transcript of Mr. Coventry's evidence, that Mr. Coventry was cross-examined on the basis that wands should have been put there instead of a raised curb, which fits with the standards and fits with, as we've seen Mr. Art's evidence, that wands are an option of lighter segregation on a flat surface. But what the learned judge did was, Mr. Coventry, having made various concessions about the advantages of wands, essentially as a method of light segregation on the flat, the learned judge took that and applied it to his design or his requirement that the wands needed to be actually built on top of the upstand. And this is where I said that the learned judge fell into real error, because he essentially came up with a new standard that combined a method of light segregation with a method of full segregation. And I've said in my skeleton, this is unheralded by any standard. Finally, so the judge having found breach at paragraph 147, at paragraph 148, the learned judge essentially repeats his finding that there was a hazard on the highway which posed a reasonably foreseeable risk of injury to cyclists, and then he went on, there was at least one reasonable step which TfL could have taken to mitigate the hazard posed by the upstand, and that's the row of wands, as we've seen. And finally, at page 87, paragraph 149.
Well, don't rush off. What? As an alternative, they could have replaced it with a splayed curve, and that's a reference back to 145.
Yes.
Where he shows he appreciates the point you're making about the converse risk that motorists will stray onto the SCT. But what is a splayed curve? It means nothing to me.
A splayed curve, as I understand it, is rounded. It's more of a hump.
It would be chamfered.
Yes.
chamfered up to the level of the.
Yes. So
But the evidence, I can't remember whether it's the evidence from WSP, but the evidence is that wouldn't make a significant difference to the prospect of falling off.
and of course,
Or the judge finds that it wouldn't make a significant difference.
yes, the obvious disadvantage to the splayed curb is that motorists can encroach onto it.
But that's a different point.
Did the judge make any finding about that?
No, my lady, at paragraph 145, the learned judge the learned judge discounts the splayed curb option on the basis that he hadn't heard any evidence of the cost of replacing the vertical upstand with a splayed curb, on the basis that it would be easier for motor vehicles to stray from the carriageway and thereby increase the risk of harm to users of the track. And
Yes, so he finds it would not have been reasonable to expect them to replace it with a splayed one.
yes, so there was no finding of breach for having an upstand rather than a splayed curb. And then at paragraph 146, the judge considered the alternative of having painted markings on the curb. I think they were called blips at trial, but the court may have seen them. They're restrictions on parking, and they're not just on, they're on pavements where there are vertical double lines positioned at the edge of the curb to indicate an area where there shouldn't be any stopping.
The whole way down Wigmore Street. Not Wigmore Street, not Wigmore Street, the street that comes down parallel to Tottenham Court Road.
Yes, and indeed,
Actually, the whole way down.
ironically, there are these blips on the pavements around the Mayor's and City of London County Court, where this case was tried. So the judge probably had them well in mind.
So at 145, the judge specifically finds it would not have been reasonable
Yes.
to expect them to replace with a splayed curb. But then at 148, he refers to an alternative being replacing with a splayed curb.
Yes, so this is...
There is some inconsistency.
There is some inconsistency, my lady, and it's... well, if I can put it this way, suppose for a moment that the judge had discounted all three possibilities. As we know, he discounted two and allowed one. But suppose he had discounted all three possibilities, including the ones, as not steps that were reasonably required. Then there is no way that the defendant could have been found to be in breach of duty. And I would have had what I would submit would be an unassailable ground of appeal, that what the judge can't do is say, well, none of these three things are reasonable, but you're in breach of duty because you could have thought about doing...
I'm not sure that's right, actually, speaking for myself. If the judge finds there's a danger that has been created by the defendants, then he has to consider whether the defendants have acted reasonably. That involves a balancing exercise. Is it for the claimant to prove that there was a particular measure, particularly when the claimant's not been allowed to call expert evidence? Or if the judge concludes that, is it not open to the judge to conclude that the defendants haven't established that they've taken sufficient measures?
No, but I did my submission, it's for the claimant to prove. And I say that, and perhaps we'll go back to
How's the
Tomlinson.
claimant meant to do that without expert evidence?
Well, this is where we get into the issue that these points in my submission weren't pleaded. Had they been pleaded that there should have been a row of ones on top of the upstand, then maybe the district judge would have taken a different view. But ironically, this point was only pursued by Mr. Upitis' counsel, and Mr. Upitis was not the party who asked for expert evidence.
Isn't the correct analysis that it's for a claimant who's alleging negligence to prove that the conduct was unsatisfactory? But once a claimant establishes that there's a reasonably foreseeable risk of injury, there's an evidential burden which will shift to a defendant to demonstrate that reasonably foreseeable risk of injury was not the consequence of negligence. So it may not be a legal burden, but it's certainly an evidential burden.
Or rather, to establish that they had taken reasonable measures
Yes.
in light of that foreseeable risk.
You'd be a bit rash if you turned up without your backup case as a defendant in the face of a finding of reasonable risk of, reasonably foreseeable risk of injury.
You would want to, I suppose, the way I look at it is that determining breach of duty, it's not a straitjacket. It's not a two-step process of, is there a danger? If there is, can the defendant show on the evidence that it has taken all reasonable steps to mitigate that danger? In my submission, it's more nuanced than that, as Tomlinson tells us, which is that the question of breach of duty requires a balance. It's not as simple as binary danger.
Yes, I accept that. But that's why I was drawing the distinction between a possible distinction between a legal burden of proof, which may rest on a claimant, but a claimant may do sufficient by establishing that there is a reasonably foreseeable risk of danger to create an evidential burden upon a defendant to say, well, there may have been a danger, but we took reasonable steps, or it was reasonable for us not to do more, or whatever.
Yes, I cannot. This is perhaps this is the Wharton Tesco point. My lord might be familiar with that case. The yogurt on the supermarket floor, and the defendant having a system of inspection that it couldn't evidence. And in that case, in circumstances where there's a closely controlled supermarket that's meant to be under supervision, there's an evidential burden to show that.
Exactly.
Yes.
And the claimant won.
Indeed. In my submission, not in this type of case.
Well, TfL have complete control over the layout of this road.
And the judge found that it was negligent of TfL to fail to replace the bollard, but for reasons set out in paragraph 141, which I find rather puzzling, he found that it wasn't causative, that was a finding which presumably, if this judgment is to serve as any guide to the future, the judge is holding that it was open to TfL to replace the bollard, and had he accepted the claimant's evidence about causation in their cases, he would have found against TfL on that basis. I suppose then you'd be appealing that.
Yes.
But you called no evidence to say there is absolutely nothing we could have done.
Well, in my submission, my lord, there was evidence. We had the road safety audit and the designer's response to that, which spoke of all the measures that the defendant did. I do say, regardless of the evidential burden and the cases in which it may arise and the cases which it doesn't, a claimant still has to plead their case. And we do come to the ground, well, I will come to the ground, where I say that was not a case. This pivotal finding at paragraph 147 was not pleaded at all. And so how was the defendant to know that was the case it was expected to meet? But as I say, that's a ground that I'll come to.
So just going back to the judgment, the judge finds splayed curb would not have been reasonable, so not reasonably required. Then he finds in relation to the blips, the painted stripes, that essentially he's not going to go down that route because it wasn't raised in advance, that wasn't pleaded. So are they the two other measures you referred to that he rejected, or are they
So there are three measures canvassed.
right?
The splayed curbs and the blip markings are the two that the learned judge rejects at paragraphs 145 and 146. 147 is the one that the learned judge accepts about wands.
And then the judge says another alternative may have been to paint or fit an already painted curb so as to highlight the upstand. He doesn't reject that anywhere, does he?
No, as I understand it, that is a reference to the painted markings at paragraph 146. I read those as the same thing.
Not how I read it, but and there may have been other options which I have not considered.
Yes.
As the judge. All right. You see it as 3 measures. He rejected 2, and leaving only the wands.
Yes.
You were saying that wands, or failure to place wands, was not pleaded. You're right. We haven't looked at the particulars of negligence yet.
No, my lord, we find those, they're in the core bundle.
Mr.
Perhaps if we start with Mr. Young at page 112.
Yes, yeah, I was looking at those.
The court may have seen from the amplified reasons, the learned judge's view was that the issue about wands, if I can put it like that, was raised by both pleaded allegations of negligence. And my submission is essentially the learned judge was wrong about that. Turning to Mr. Young's allegations first, subparagraph C is the closest that we get, failing to remove and or adapt the dangerous curb upstand on the road so it no longer represented a danger to road users. In my submission, that no fair reading of that allegation could put a defendant on notice that it was being alleged that there should have been wands installed on top of the curb upstand.
Sorry, you're referring to which subparagraph?
Subparagraph C.
It's about E.
Yes, well, this is the bollard issue. So there is absolutely no doubt the defendant was on notice of the need for there to be, that the allegation being that the bollard should have been there. That was well canvassed in the evidence.
But bollards and wands seem to be used by the defendants interchangeably in some parts because there was a recommendation for a wand which became a bollard.
Indeed, and we'll see this in the road safety audit report. There was a reference to it being a wand rather than a bollard, and then in the fullness of time, it was a bollard rather than a wand. But that, of course, is a very different proposition.
Well, what about H then?
Yes, that's the allegation about warning cyclists. So I can see how that engages the issues about the red lines on the carriageway. I can see how it engages the issues about the white triangle up ramp sign. I can see how it engages an alternative warning to a bollard. But what in my submission this cannot put a defendant on notice of is the installation of wands along the edge of the upstand, not to act as a warning, but to act as an impassable barrier.
Yes. Well, it's still on page 112A, which is a point which my lady has referred to. The allegedly confusing or illogical changes in the cycle tracks as you travel south along Farringdon Road. I don't think it's mentioned by the judge.
No, it's not. The judge didn't. I can't say whether it was really, if I can put it like this, pushed in submissions. But it's certainly not something that the judge dealt with. if I could say this though, it would be difficult to see how it could be said that the layout was illogical or confusing in my submission. But in any event, the judge didn't.
Why is it difficult to say it's confusing when that is exactly what the risk assessment identified, isn't it?
Well, the risk assessment identified the potential risk that some cyclists wouldn't notice the upstand, but this is a wider point.
Specifically identified the risk that a cyclist would think it was a continuation of the previous cycle track and the white line. And I think it actually used the word confusion.
Yes. I suspect this feeds in to, well, essentially the learned judge found that there was a risk that some cyclists would fail to notice that difference. But the judge didn't put it on a broader basis. The judge didn't put it on a broader basis of a confusing or illogical layout. So my submission is that essentially none of these particulars put the defendant on notice of the need to call evidence, whether that's expert or evidence from its professional witnesses, about having wands built along the edge of the cycle track to act as a barrier rather than a warning. For completeness, we should probably look at Mr. Upitis' allegations of negligence at page 145. And again, in my submission, there's nothing in any of these allegations that can put a defendant on notice of the allegation that wands needed to be constructed along the edge of this cycle track.
I seem to, on the subject of appalling discrimination, my bundle goes from page 143 to 146. And you want me to go to 145?
145, my lord, yes.
Yeah. Could, it'll be in the electronic bundle, that's okay. I'll find it.
Will, but I'm sure we can.
Can somebody sacrifice their pages 144
Yes.
and 145?
The author of my
Forgive me, Lord, was it 144 and 145?
Yeah. Thank you very much.
Thank you.
Sorry, whose counsel cross-examined on the wands point? I can't remember.
Mr. Upitis' counsel, Mr. Jackson.
Thank you so much.
But as I indicated, I will take the court through that cross-examination. It's only about 3 pages of the transcript, but it's going to be important to see the basis upon which Mr. Coventry was cross-examined. I've rather jumped ahead to the pleading point, but does the court have my submissions on that, or is there anything else I can assist with?
So, again, so paragraph D talks about bollard signs or other notifications of the presence of the upstand. You're saying the judge found the one should be a barrier rather than a warning.
Yes. 2 points, my lady. One, there is no mention of the need to construct the barrier of wands. And the second is that the purpose identified by the judge was for them to be a barrier and not a warning. So it can't fall within that.
If it was a warning, then subparagraphs D and H of these particulars might be seen as covering it, but not as a barrier.
Yes. Although again, it's the H, for example, says fail to ensure that a cone, sign, or other method, you may recall that when this bollard went missing, there are pictures of a cone there instead. So it's a tighter allegation that's being put there. And I would highlight that the learned judge in his amplified reasons deals with the pleading point, and it doesn't refer to those allegations as the ones which he said entitled the claimants to make those points. I think I was at. I think that's everything that I intended to take the court through in terms of going through the judgment, unless there's any paragraphs of the judgment that I can usefully deal with before we move on.
No.
I should also mention, of course, the amplified reasons. Perhaps we'll look at those very briefly. They are at page 89 of they're immediately following the judgment.
These were handed down after the judgment had been handed down.
Yes, they were. It was simply circulated to the parties.
For a consequential hearing, was it?
No, it followed. I can't remember exactly when we received them, but it was after the consequentials hearing, after the learned judge had given permission to appeal. I'm not sure if it was before or after the Court of Appeal had accepted the transfer up. But
well, I mean, we get some indication of the date from paragraphs 1 and 2.
25th of June, according to page 88.
Thank you. That's 6 months later. 5 months
And that by this time, Lady Justice Andrews had given permission, accepted the transfer up.
yes. So I put an authority in the bundle about the prospect of the Court of Appeal taking into account further reasons given by the court below. Really, that authority is to highlight the need to be alive to the potential for, after the event, reconstruction or
Yes.
But in these amplified reasons, and essentially my submission is going to be the amplified reasons don't repair the defects in the judgment that I put before this court. But I do ask the court to bear in mind that there is a danger of ex post rationalisation. But I point out at this stage that paragraphs 4 and 6 are where the learned judge says that he was satisfied that the issue about wands was pleaded, and those are the allegations that he's referring to. At page 90, at paragraph 12, what the judge does here is really set out in even more detail this distinction of purpose that the wands are to serve. At paragraph 12, the learned judge repeats that he concluded it would have been reasonably practicable to install a row of wands that would have presented an impassable barrier to cyclists. And then the learned judge goes on to talk about the prospect of cyclists cycling at different speeds, all within the speed limit, 12 miles an hour, 20 miles an hour, and the need for the wands to be spaced sufficiently far apart that a cyclist couldn't go through the barrier. But the point that I underline at this stage is really that which I made earlier, that the judge is not anywhere saying that the wands were to act as any kind of warning. They were to act as a impassable barrier. It's a point I've already made. But think what I may do first is move to the grounds 1 and 3 of this appeal, which is the pleading issue and Mr. Coventry's evidence. I think it's perhaps sensible to deal with that now, as we've been looking at the pleadings. Before I launch into those submissions, I want to just take a moment to ensure that the court fully understands the different relationship between Mr. Coventry, who was from the road safety audit team, and Mr. Artis, who was from the defendant's design team. If I could take the court to begin with to Mr. Coventry's evidence, which is in Supplementary Volume 1, page 146. And if I could just take your lordship's, your ladyship's eye to paragraph number 7 on page 146 and just invite the court to consider that. What the court will see there is Mr. Coventry explaining the difference between the road safety audit team and the design teams, talking about the impartiality between the two and between the road safety audit process. And that essentially what the road safety team do, or department do, is to critically evaluate, to provide a design assurance function, to identify potential issues with a proposed design, and highlighting them for consideration, and then that the design department is required to demonstrate due consideration for any issues raised within the audit. But, importantly, no obligation to adopt the recommendation. Now, we see that playing out, and I do say it's important to understand there is a relationship of challenge and review here. The road safety audit team are responsible for critically evaluating, raising, challenging safety issues, and seeing that the design team demonstrate due consideration for them. The best example of this is perhaps how the raised up stand was dealt with by the road safety team and the designers in respect of the risk that was identified. If we could turn please to page 177 in the bundle that we're in. This is the stage 1 road safety audit that Mr. Coventry was responsible for producing pre-construction of the cycle track facility. And I just underlined paragraph 1.2.3 on page 177. That nothing in this audit should be regarded as a direct instruction to include or remove a measure from within the scheme. Responsibility for designing the scheme lies with the designer. At page 180, we have the problem that we've already discussed in this appeal being flagged pre-construction. 3.1.1. Problem, hybrid track design may pose a hazard to cyclists and riders of other two-wheeled vehicles. And I would just invite the court to consider the summary of the problem that the road safety auditors identified.
Hybrid means stepped, does it?
I imagine it must do, my lord, simply because they are dealing here with the curb upstand.
Yes.
That's the risk that's being highlighted. The court will see the recommendation: ensure the hybrid track is adequately visible to all road users. That's, of course, cyclists and motor cars. This may require, but is not limited to, the provision of additional road markings to define the edge of the carriageway and the use of a different surface material and or colour. So some recommendations, but of course, as the court will see at the moment, the designer's response is blank. It's 180. The designer response is at page 206. And again, I would just invite the court to consider, in the margin it says problem 3.1.1, which is the hazard that we've just referred to.
I'm sorry, I've got the wrong page.
Page 206, did you say?
206, my lord.
Thank you.
Yes.
As I say, there's a couple of paragraphs that I would just invite your lordship, your ladyship, to consider, which is the designer's response to that hazard.
Sorry, I'm not sure what specific paragraphs you're referring to.
My lady, there's a line that says the designer's response stated, and then there are two italicised paragraphs.
That begin part accepted.
No, my lady, it's immediately above that. Problem 3.1.1 in the left-hand margin.
On page 206,
Yes.
the designer's response stated.
Rejected, the double red line, no stopping restrictions highlighted.
Oh, sorry, problem 3.1.1 you said, sorry.
Yes, that's the problem that was
Sorry, I
identified.
thought you said 3.12.
So we have there essentially the designers referring to the double red lines that highlight where the edge of the carriageway is, and that at the edge of the carriageway users are accustomed to a curb height, that these 50mm curb heights are increasingly common across London, especially in busy high street contexts and along existing cycle superhighway routes. Confusion hasn't been raised as an issue, as cycle logos, and then a potential point of confusion at the start of the step cycle track. In fact, that deals with my Lord Justice Bean's point about hybrid, because it says all stepped cycle track.
Yes.
It proposed a triangular ramp marking, a cycle logo, a retro-reflective yellow wand. I think, my lady, that goes to the point that you raised with me about it not being a bollard at that stage, it being a wand, but a single wand. And tapered road markings on the approach to direct other traffic away from the track, and will highlight the presence of the track and the level change. And then importantly, just beneath that, the road safety team has said the designer appears to have given this problem due consideration, and therefore this will not be raised again.
So there, the designer is saying that those features, including the yellow wand, will highlight the presence of the track and level change. And then the risk assessor, it will just says the designer appears to have given the problem due consideration.
Yes, I think it's fair to say some of these will highlight it more than others.
Yeah, that may be so.
I don't read it as saying that the yellow wand will reveal the step track. Indeed, after discussing the yellow wand, the paragraph goes on to say, on the approach to direct other traffic away from the step track, will highlight the presence of the track and level change. So I accept to an extent these things are to work in concert.
Were those installed? The tapered road markings on the approach to direct other traffic away. I think there's an assertion somewhere that everything in this was done, but I'm just thinking about the photographs and I'm not quite sure what is being referred to, but I'm not at all sure what's being referred to as tapering. So if you go to 583, to my eyes, if you look at 589, which is from slightly further back, or 591,
Yeah.
if you look at 591, you've got the cycle lane to the left expanding across the carriageway at the traffic light.
Yes, that's the box for the.
Yes.
Yeah.
But then that leaves the carriageway where, in this plan, it says Farringdon Road going away from us. And you can then see, you go further on, and at the moment, speaking entirely for myself, I can't see any tapering of anything because it's not necessary, because the carriageway goes straight on,
Yes,
as indeed does the cycle lane.
it does, my lord. Yes, we have the advisory cycle lane with the dashed white lines leading up to the entrance of the SCT.
It may not matter, because I don't at the moment understand how you could have
How one could taper something.
tapering signs when the width of the cycle lane remains constant.
The other point to note, of course, is that referring back to page 206, the problem 3.1.1 that we're discussing is general to the whole scheme, multiple locations. So it's not just this Farringdon Road
Yes.
site. So there may be other locations where tapering
Yes.
is required, whereas it's not here. The designers do go on to deal with problems that are raised with the specific sites, but the issue that we're concerned with in this case was a general one.
Okay. Would you, if only to humour me, confirm and, if possible, agree with your learned friend that the tapering is a general provision and not specific to this area? Because as I'm looking at the materials we've been given, I can't see any scope for tapering.
No.
Unless I've completely misunderstood what the response means.
Yes. I'm sure over the lunch we can.
Well, I can do it now. I take no point in that at all. I entirely see your point, my lord. I don't think it takes us any further at all. The tapering.
Thank you.
So is this the only part of the report where the relevant risk is identified? There isn't anything specific to the accident location?
Yes, that's correct. But this rather, I mean, this underscores the point that I make, my lady, which is that we are dealing here, if this step cycle track is dangerous and needs to be guarded against with the barrier of wands, then that would apply to all of them in my submission. Because they are a general feature that are, as is said here, increasingly common across London. I've already taken the court to Mr. Artis's evidence. I won't go back to it, but I asked the court to remember that paragraph where Mr. Artis set out that when considering the options for the segregation, the decision, or the choice as it were, was segregation with an island, full segregation with an island, full segregation with a stepped track as occurred, or wands, which we know are a method of light segregation. Part of the trouble in this case was that the claimants, for whatever reason, chose to cross-examine Mr. Coventry on these matters and not Mr. Artis, even though Mr. Artis was the one who had mentioned wands in his witness statement in that context. The claimants may have had their own reasons for wanting to cross-examine Mr. Coventry rather than Mr. Artis from the design team.
Who went first?
Mr. Young's counsel went first.
No, sorry. As between Mr. Coventry and Mr. Artist, who gave evidence first?
I will double check, my lord. This trial was in December 24th. I will double check.
You're being volunteered the information from behind you.
Yes, Mr. Coventry went first.
Right.
Mr. Afters.
Maybe everybody was exhausted by the time Mr. Coventry.
Well, Mr. Coventry certainly would have been. You'll have seen reference in the transcript to his cross-examination being hours.
Yes.
Number of hours. So, be that as it may, Mr. Coventry was the one that was cross-examined on these issues. I do want to highlight to the court that Mr. Coventry did, in his oral evidence, on a number of occasions, make the point that he wasn't a designer and able to answer a number of the points that were being put to him. I'll just put before the court a handful of those examples. In the bundle that we're in still, Supplementary Bundle 1, at page 52, first of all, I should say, to avoid any confusion, the transcribers have referred to me as the person cross-examining Mr. Coventry, which is wrong. At line 6, towards the top of the page, Mr. Coventry gives an answer. I'm not a designer. I'm not 100% sure of the legality and the use of which of them. This is a point about using red lines to signify a curb upstand. And at line 23, it said to Mr. Coventry, well, I appreciate you're not a designer. We've established that. What I would like to ask you, though, is your perspective as a safety auditor. We have at page 66 a similar, towards the foot of page 66, at paragraph 25, line 25, Mr. Coventry says, just to be clear, the designer is the person whose proposal is provided. My role is just to consider what is provided. I do not state what should or should not be there. And then at page 72, at line 28, in fact, page 92, sorry. At page 92, line 15, Mr. Coventry says, I bring you back to my evidence yesterday that my role as a road safety auditor is to design a sure assumption. My role is there just to make sure that safety concerns are given due consideration by the appropriate people in other areas. And as the learned judge said, so you're there to flag up issues, not resolve them. So it was very clear that Mr. Coventry was not a designer, was not the person who was there to give evidence about what should or should not be there, was just to give evidence about his perspective as a safety auditor, raising the issues, but not determining whether there were appropriate methods that should have been put in.
What was he giving evidence about? The defendant chose to call him, so what was the purpose of his evidence?
He was the gentleman who completed the road safety audits, the lady. So he was, his evidence went to the issue of reasonable foresight of harm, essentially, but not the issue on which, as we'll see, he was cross-examined, which is really the appropriateness, practicability and so on of the protective measures. I'll take the court next to what Mr. Coventry was cross-examined on, but just before I do, I wonder if I appreciate this as a document we've been to before, but it's important because this really provides the template for the cross-examination of Wands on Mr. Coventry. It's in page 400 of supplementary bundle number 2. For completeness, I should just take, in fact, the court back to page 398, which is the London Cycling Design Standards, the section on light segregation, including wands. And what this document does is set out what light segregation is, and in fact at page 398 we can see in the top left corner some wands in Minneapolis of all places, but as an example of wands bordering cycle lane. At page 399 there's a section entitled the design considerations, and the third bullet point down on the right-hand side of the page makes the point that essentially the trouble with most forms of light segregation is that they can be crossed relatively easily by most vehicles. And finally, at page 400, there is a list of the benefits to light segregation, including wands, and I would just ask the court to read that section under benefits, because what I'm going to take the court to is this was the template for how Mr. Coventry was cross-examined, the benefits of wands.
Sorry, 399.
Sorry, my lord, I'm now on page 400. Towards the bottom left of page 400 is a heading that says benefits.
Thank you.
And it's that paragraph over onto the middle of the page, the middle column.
Yes.
So the court, just a potted summary, the benefits of light segregation, over full segregation, ease of installation, usually costs less, adaptable, does not create barriers to pedestrians moving, generally will not require excavation, physical adjustments to the structure of the carriageway, or repositioning of drainage. It should not constrain cyclists in the same way as full segregation, although this depends on the objects used and how they are spaced. And then it goes on to talk about the levels of acceptable protection from the point of view of ensuring against encroachments by vehicles of 2.5 metres and no greater than 10 metres. And also, finally, they can be adjusted or removed easily, suitable for trialling as a temporary measure. What is abundantly clear is that 2 points. The first is that wands are a light method of segregation, as distinct from full segregation by a step track. Secondly, the benefits of wands are an alternative to a fully segregated step track, as we have in this case. The cross-examination of Mr. Coventry starts on page 110 of supplementary bundle number 1 on this point. At line 27, Mr. Jackson, so as I say, this is Mr. Upitis' counsel only. Mr. Jackson says, now moving on to the issue of wands, your colleague Mr. Artis refers to wands in his witness statement and then misquotes or misrefers, mischaracterizes what Mr. Artis' statement said. Mr. Jackson says that Mr. Artis talked about wands as a method of warning of impending foreseeable risk of injury, or for want of legal expression, a hazard or an obstruction. As we've seen, Mr. Artis was clear in his statement that wands are used as a method of light segregation. They're not used as a warning. So that rather mischaracterized what Mr. Artis said in his statement. And again, a peculiarity that Mr. Coventry was being asked about this rather than Mr. Artis, but nonetheless. Over leaf at the top of page 111, Mr. Jackson goes on to say that in his understanding, wands are a light segregation method, to which Mr. Coventry agrees. That's at lines 1 to 3. At lines 21 to 23, Mr. Jackson puts to Mr. Coventry, and the purpose of those is so motor traffic cannot readily encroach onto the cycle track. And Mr. Coventry agrees that's the primary function of having wands. And then at line 26, Mr. Jackson made the point to Mr. Coventry that the opposite is true. Cyclists cannot as readily move out into the vehicle traffic. And then Mr. Coventry accepts that wands discourage but do not prevent those movements out. And then what Mr. Jackson does, you'll see at line 32, he says, well, there are plenty of benefits to wands, to which Mr. Coventry agrees. And then this really replicates the section that we were looking at in the standards. Ease of installation, at the top of page 112, less costly than major engineering. Line 16 on page 112, they're adaptable, because you can put them in and take them out. And then at line 19, they're adaptable and can be put in and taken out quite easily in comparison to a granite curbstone. So again, this is being presented as an alternative. Mr. Coventry is being cross-examined on the basis of the wands being an alternative to the step cycle track. And he goes on to say that at line 21, it's put to Mr. Coventry, they're not readily going to be mistaken for a curb, a white curb. Line 24, when you're slotting them in, you don't need any excavation. You don't need whacker plates to dig up the tarmac, unlike, for example, a granite curbstone. A simple and straightforward job. No physical readjustment to the structure. And then finally, at page 113, all that is put to Mr. Coventry is that if there had been a row of wands, and this is line 5, separating the superhighway from the carriageway, he would not have been able to enter at the angle that he did. And Mr. Jackson says, well, it would have been difficult for him to do so, and accepts that it would have been reckless and foolish to enter at an angle at 20 miles an hour of the row of wands. So all of that is to say, I realise that was something of a whistle-stop tour through the cross-examination, but the point that I intend to make is that when Mr. Coventry was being cross-examined on the use of wands, it was clearly with a view to the benefits of wands as an alternative to a stepped cycle track facility. But what we've seen in the judgment the learned judge does is take those benefits and apply that to his finding that there should have been wands on top of the curb upstand.
Yes.
And so my submission is that Mr. Coventry's concessions, such as they were, don't get the judge any closer to resolving the question about whether it was reasonable to have the wands positioned on top of this cycle track. And it's, to be clear, it's Mr. Coventry's answers that are the kernel of the judge's findings on this. And so I do make the submission that the learned judge respectfully took those matters out of context.
Yes, right. I think we've got that point, Mr. Hedgeman. Now, it's our 5 minutes or a bit more than 5 minutes to 1. And
Yes.
I hope you're going to stick to the timetable of sitting down by 3. Are you going to be able to cover the ground?
I think so, my lord. I have rather taken things out of the structure that I intended. I've not taken the court to the authorities on obvious dangers and so on, but it may be, in light of earlier, we may not need to go to those, and perhaps I can concentrate my submissions on the balancing exercise that the judge performed.
Yes, well, speaking for myself, I think there's more fact than law in this case.
Sure.
You said you particularly wanted to look at Yetkin,
Yes.
but well, it's up to you. But I don't think we need go on a tour of the however many it is authorities in this case. But in the end, it's for counsel to say.
Yes.
Right. Now, shall we? Have you got a sort of 5-minute point which you'd like to raise, or should we break?
I don't think so, my lord. I'll be moving on to a new topic.
Now come back. 5 to 2 then.
Court rises able.